Start. Para. By way of instant appeal, state is questioning the judgment and order of acquittal passed by learned judicial magistrate first class Parner in RTC number 81 of 2000, acquitting present respondents from offences punishable under sections 323, 324, 325, 504 and 506. Read with section 34 of Indian Penal Code. Para. Parner police charge sheeted present respondent numbers 1 to 3 for above offences on the premise that on 19/5/2000 informant's husband Vishnu was getting land measured through surveyor. Accused who had visited the spot initially uprooted the marking, abused informant's husband Vishnu, and thereafter accused beat Vishnu, pelted stones on informant's nephew, causing all of them severe injuries. They visited police station and were referred to hospital, and on report of PW4, crime was registered bearing number 117 of 2000. The same was investigated by PW9 ASI Dighe, who was investigating officer. Case was tried by learned judicial magistrate first class Parner, who, on appreciating the oral evidence of 9 witnesses and documentary evidence, reached to a finding that case of prosecution is not free from doubt. Version of prosecution does not pass test of credibility, and prosecution case is not proved beyond reasonable doubt, extending benefit of doubt to all respondents herein by acquitting them wide judgment and order dated 15/6/2006, which is now taken exception to by the state by filing instant appeal. Para. Learned APP would point out that prosecution had proved the charges beyond reasonable doubt, that informant herself was injured, remaining injured too, suffered injuries at the hands of accused, and they are also examined, that they all are consistent about role played by each of the 3 accused, that their testimonies have remained unshaken, that medical authorities who examined injured and issued certificates are also examined by prosecution in trial court. Therefore, all necessary ingredients for attracting charges was very much available in the prosecution evidence in the trial court. However, it is pointed out that merely accepting defense witness testimony who was examined at belated stage during trial, acquittal is recorded. According to learned APP, there was injured witness account supported by medical evidence, and therefore learned trial court ought not to have discarded or doubted such evidence. According to learned APP, trial court failed to appreciate the evidence as well as law and erred in acquitting the accused and giving benefit of doubt, and hence she prays to allow the appeal by setting aside the impugned judgment. Para. Per contra, learned counsel for accused respondents pointed out that there is false implication due to previous enmity, that there was no occurrence as alleged. According to him, independent witness DW1 Prakash, who was present at the time of incident, flatly denied any occurrence of assault by accused, as is reported by informant, that there is false afterthought and motivated complaint, that witnesses are not consistent, that medical evidence does not tally with injured witness account, that medical witness is not foolproof regarding injuries, and thereby, according to him, learned trial court committed no error in refusing to accept the case of prosecution. According to him, there is correct appreciation. Learned counsel emphasized that in view of acquittal passed by learned trial court, there is strong presumption of innocence in favor of accused, that in appeal same cannot be disturbed, more particularly when there is correct appreciation and possible view is taken by trial court. For all above reasons, he prays to dismiss the appeal. Stop.